Hi guys, and welcome back to Contract B. This is the part 2 video for topic 5, illegality and void contracts. So without further ado, let's have a look at contracts that are illegal at common law. And there are 5 main pieces of the puzzle here. The ones we're looking at today are contracts to commit a crime, contracts that are prejudicial to the administration of justice, contracts that promote corruption, contracts that promote sexual immorality, yes, you heard me correctly, and contracts that are prejudicial to national interests. So just thinking about illegality at common law more generally, everything really turns on public policy. What would public policy say are the things that should be illegal here? And that's where your 5 heads of public policy have cropped up ever since Holman and Johnson. You've got those 5 heads there that we've talked about in the last slide. That you need to realise, however, that where a court is constrained by the circumstances of a particular case that don't necessarily fit within one of these 5 heads, then it may well be like they did in Fitzgerald and Leonhardt, that a more flexible approach might still yield a result of illegality, even though the conduct at issue doesn't necessarily fit within one of those 5 heads very nicely or very easily. Certainly that's the case with statutory illegality, where Fitzgerald and Leonhardt arose, although the text does make the point that it may well be that this more flexible approach does apply to illegality at common law, but this is one of those points that just hasn't been really definitively settled just yet. So we know that we have these 5 heads. We may also have this broader kind of catch-all public policy head of illegality. We don't really know yet. Okay, so the first of the big ones is crime. Obviously, this is fairly easily. Do you think you could enforce a contract for murder? No, obviously. One of the cases, most of the cases are fairly old, but Coward and Milburn was an 1867 case. In that case, you had the contract for a lecture room, and in that lecture room, they were going to deliver lectures which the court considered blasphemous. At that stage, blasphemy was a crime, and therefore the contract was illegal at common law. On this issue, it doesn't really matter if it was statutorily prohibited or prohibited at common law. Either way, the result's going to be the same. It doesn't really matter if you don't know about the existence of the prohibition. It's still going to be an illegal contract anyway. However, the commission of the wrong, the commission of the crime that's involved here, or it might be a tort, must be more than subsidiary to the main purpose of the contract. So it's just like some kind of minor incidental event, then, that may well be sufficient to save the contract. However, if it was more than subsidiary to the main purpose, then the contract will be declared illegal. Like I said there, like they discuss in the text, same thing will probably apply to torts and also other civil wrongs. Okay, so that's illegality at common law, where the contract is to commit a crime. Turning to the next one, illegality where the contract hinders the administration of justice. Here we have contracts that do things like cover up crime, stop evidence getting to trial, and preventing an investigation. And here we have the case of A and Hayden. And just on that point there, it is A and Hayden. So I don't know if you've been told in previous units, but in civil cases, you don't say A versus Hayden, you say A and Hayden. If it's a criminal matter, you will say A against Hayden. So there's no reference to versus in English or Australian jurisprudence. We say and or against. So A and Hayden. And this involves some rather naughty Secret Service personnel who had to conduct a mock raid on a hotel. That's fine, but in the course of doing so, they trashed the hotel and they upset quite a few of the guests of the hotel. Now, obviously, the hotel personnel and the guests and the hotel owners were all pretty upset about this. The police wanted to press charges. The Secret Service, I don't know if you know, but they have a nice little clause in their employment contract that says, because of the nature of your duties, it's important to keep your identity confidential. And so the rather naughty Secret Service agents in that case sought to rely on that provision in their employment agreements to say that they shouldn't be disclosed, their identities shouldn't be disclosed, and therefore the police wouldn't be able to investigate. It went all the way to the High Court, rather incredibly, and the High Court said, look, in this particular circumstance, you can't hide away from an investigation into a crime. The contractual provision in relation to confidentiality here was contrary to public policy because it did prevent that investigation of a crime, and so therefore the Secret Service couldn't hide behind that provision in this circumstance. So to rely on it would have actually hindered the administration of justice. Again, not too difficult to get your head around conceptually. The next one is contracts promoting corruption. And here we have the rather wonderful case, surprising but maybe not so surprising case of Wilkinson and Osborne. Here we have some New South Wales members of Parliament. And they come to an agreement with the land agent that they would use their parliamentary influence to get the government to buy a property that belonged to the land agent's client. Oh my goodness. After the sale, the MPs put their hands out. Where's our money? You know, we want to be paid. We used our influence. And not surprisingly, the land agent said, hang on a minute, what's the story here? This is probably an illegal contract. And again, rather incredibly, went all the way to the High Court. And not surprisingly, the contract was against public policy because it tended to promote corruption in public life. There was a very clear conflict between the duty that these members of Parliament owed to vote impartially on this particular land deal and their obligation to use their influence to get the deal across the line. So there you have contracts promoting corruption. Again, not too hard to get your head around conceptually. Contracts against the national interest. This one's probably becoming a little bit more important in this day and age, rather unfortunately. But the case law that we have tends to be centred around wartime events. And the kind of contract that this head of policy is designed to prevent or prohibit and therefore make illegal are things like where you've got contracts entered with a national of a country that's at war with Australia, contracts with persons that live in an enemy country or in enemy occupied territory. Obviously these kind of contracts are going to hinder the war effort or might help the enemy in some way. Also contracts assisting someone to breach the laws of a friendly state. Obviously you don't want to be embarrassed so far as a friendly state's concerned. You certainly don't want to be allowing contracts that would hinder your relations with your friendly states. Again, rather unfortunate, but a necessary provision that, like I said, is becoming probably more relevant. One that's becoming less relevant. Sorry, can't help myself with this one.
Hello, young lover.
Contracts promoting sexual immorality. You have to apply the moral standards of the day. Well, there's your first clue that this might not be quite so relevant in this day and age. Is there such a thing as a moral standard that the court can apply? I don't know that there is. There are so many different forms of sexuality, and none of them are discriminated against in today's day and age. So really, is there a yardstick that we can even use for these kinds of things? I don't know. old case law here, probably mostly of historical interest. But in the olden days, you used to have contracts declared illegal where they would promote the continuation of unmarried cohabitation, so de factos, or contracts in relation to prostitution. Again, prostitution is legal in most places nowadays, so as I say there, it's really just something for you to note and then move on to more pressing matters. So that is illegality at common law. And now what we need to do is consider consequences. Again, this is a pretty good jumping off point to make it the end of the second video, and we will come back for the third video and look at consequences. See you then. Bye guys.